For the Senate to consider my legislation, the Banning Unlawful Machine Gun Parts, or BUMP, Act. More than 20,000 people gathered for a large outdoor music festival. No one could have anticipated the nightmare that was about to unfold then. Then over the music, they started to hear what at first people thought were fireworks. Complete panic erupted. Rapid gunfire rained down on the crowd, with shots so close together that they seemed to almost bleed into each other. Concert goers ran in every direction, searching for cover where there was none.
Now that the matter of concealed carry bans has made its way back to the Supreme Court, there has been a noteworthy development that suggests the new approach the court will take in dealing with states like New York that are refusing to follow the Bruen judgment. Revisiting New York law. The issue of concealed carry and various bans in defiance of the Second Amendment, as highlighted in the Supreme Court's recent Bruen decision, is now back in the hands of the Supreme Court. You may recall that 5 cases had been expedited and had hearings before the Second Circuit Court of Appeals due to recent warnings the Supreme Court issued regarding the Second Circuit's defiance of Bruen. These 5 cases challenge New York's new Concealed Carry Improvement Act. This New York law created a hyper-restrictive concealed carry law as a direct response to what the Supreme Court said in Bruen. The state of New York passed that law just 8 days after the Supreme Court issued that 6-3 landmark decision.
We're not trying to hide things. In fact, after
seems like it.
With 10 carloads of armed agents and kick in someone's door with no warning.
A pistol permit holder in New York State, you might have to recertify online
parameters under which someone can get a concealed carry permit.
They must go through firearms training and an in-person interview.
Whether the Constitution guarantees the right for New Yorkers to carry firearms in public.
New York and the Second Circuit continue to defy that express decision. Now, Guns of America has asked for the Supreme Court to re-review their Antonyuk case, once again challenging New York State's defiance and seeking to strike down these concealed carry bans. One very interesting aspect of this case is that the Antonyuk case was set for conference. It technically went to a conference, but out of that order, no one received a relist. No one got an order list stating that it was granted or denied, nor did they get a relist of the Antonyuk case. Instead, the Antonyuk case has been put on hold, which signals something very specific is about to happen. What is likely happening now is that the Antonyuk case has been put on hold because the Supreme Court is set to decide the Rahimi case.
I'm not asking you about short-barreled rifles. I know what short-barreled rifles are qualified as in the National Firearms Act.
This is a semi-automatic handgun. As quick as I depress the trigger of this Glock 19, a round comes out of the chamber.
We also recently got the Cargill bump stock decision, authored by Thomas, which likely signals that Alito is going to be writing the Rahimi decision. This development is very positive for supporters of armed rights. Alito is expected to write an impactful opinion, and the Rahimi decision is anticipated to apply the Bruen decision to domestic crime restraining order restrictions directly challenged in Rahimi. With the Antonyuk case now being put on hold, it likely indicates that the Supreme Court's decision in Rahimi will directly impact this concealed carry dispute, the application of Bruen, and probably many other Second Amendment cases as well. Once the Rahimi decision is issued, we are likely to see a grant, vacate, and remand of the Antonyuk case. Concealed Carry Improvement Act. If you're not familiar with what is going on in Bruen, the Supreme Court struck down New York's original may-issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. One of the primary findings of Bruen was that the government bears the burden to prove that their restrictions or regulations are based on the history and tradition of our nation, and those types of restrictions must date back to 1791. Despite the Supreme Court issuing that 6-3 decision in Bruen, just 8 days after that decision, the state of New York passed the Concealed Carry Improvement Act. The CCIA created a scheme that was even more restrictive than the one that existed prior to Bruen. This New York law, passed in direct response to Bruen, was then challenged by multiple organizations in federal district courts, one of those being the Antonyuk case filed by the Gun Owners of America. In the Antonyuk case, the case originally sought emergency review from the Supreme Court due to the developments in the lower courts. The district court ruled in favor of the plaintiffs, granting a preliminary injunction. However, the Second Circuit then granted blanket stays on that decision, essentially halting the lower court's injunction. Initially, the Antonyuk case went for an emergency review from the Supreme Court, but the Supreme Court denied it. One positive outcome of that denial was that Justice Alito provided language indicating that while they would not step in on an emergency basis at that time, the Second Circuit had to correct the issue.
Urging the Supreme Court to do what they did. So the majority leader has decided to bring up a bill called the Bump Act. Claims this bill will ban bump stock. The Bump Act targets common firearm accessories, not just bump stock.
The Second Circuit was instructed to either issue an opinion with a rationale for granting the blanket stay or expedite the hearings in these cases. The Second Circuit chose to expedite those hearings. Recently, the Second Circuit held hearings and issued their ruling on all 5 of those CCIA cases. The Antonyuk case was significant because it challenged the CCIA restrictions at large, including the sensitive location provisions and the permit process. The Second Circuit ultimately vacated the preliminary injunction that the lower court had granted. In its decision, the Second Circuit attempted to distinguish Bruen as an exceptional case. They argued that because Bruen was an exceptional case, dealing with an exceptional issue, they could vacate the lower court's decision in Antonyuk. They claimed that Bruen and Antonyuk were not the same, asserting that Bruen addressed an exceptional issue, whereas the CCIA law, passed in direct response to Bruen, was not exceptional. In response to the Second Circuit ruling, further legal action and scrutiny are expected as the legal battles over the CCIA and its implications continue.
Would depend upon the actual design of the individual item. There were numerous different items being manufactured.
ATF estimates that not requiring the $200 stamp from the NFA for a short-barreled rifle. 20 years as a prosecutor, you know the answers to these questions. I'm done asking them. I'm just going to go with them.
34.
Congress passed a law. They didn't. When did the U.S. House pass a rule classifying a pistol brace as a short-barreled rifle?
Review of Antonyuk case. The fact that this case interacts directly with Bruen, the decision, and New York's response to Bruen makes it a strong candidate for Supreme Court review. GOA has filed a petition for review, even though the matter is still at an interlocutory stage. This case is highly compelling for the Supreme Court to grant the petition for a number of reasons, including the fact that the court has already indicated in previous rulings that it would step in for reconsideration if the Second Circuit Court failed to appropriately review the matter. This would have far-reaching consequences, not only for New York, but for many other states as well, including California, which just passed a law similar to SB 2 that limits concealed carry. The litigation in California is related to this case. It's also being reviewed by the Ninth Circuit Court of Appeals, which has already signaled during some of the oral arguments that they might defer to what the Second Circuit said. They might adopt what the Second Circuit said in the Antonyuk case, finding that SB 2 in California is also not an exceptional case, and therefore doesn't require the application of Bruen. That's already what the Ninth Circuit is signaling, so the Supreme Court's review of the Antonyuk case is extremely important. Recently, after the petition, the Antonyuk case was scheduled for a Supreme Court conference a couple of times. The most recent reschedule and conference happened on June 6th. The following week, we were keeping an eye on the order list to see what happened. One of the interesting things with the Antonyuk case is that the conference for Antonyuk also involved all the Illinois Rifle Magazine ban cases. The following week, we didn't see these cases on a grant or denial list, but we also did not see a relisting of this case. Soon, we pretty much got a signal that it would not be relisted for a new conference. Instead, Antonyuk appears to be on hold. Now you may be asking yourself, what does that mean? What does it mean that Antonyuk is now on hold after it went to conference and is not being relisted? The case being on hold suggests that the Supreme Court is waiting for a related decision, such as the one in Rahimi, before taking further action on Antonyuk. This implies that the outcome of Rahimi could significantly influence the direction and decisions regarding Antonyuk and similar cases. Second Amendment rights. This basically means that the Supreme Court will not make a final decision on these matters until they issue a larger decision, which is similar to what they did before the Bruen decision. Truthfully, what is likely taking place is that the Rahimi issue is about to be decided by the Supreme Court. The Rahimi case is expected to be resolved before the end of the Supreme Court term, likely by the end of June or early July. This case deals directly with the application of Bruen and the Second Amendment concerning federal restrictions on individuals possessing arms and ammunition who are subject to domestic crime restraining orders. The Rahimi case came out of the Fifth Circuit. The Fifth Circuit panel stated that using Bruen's application and the Second Amendment, this type of federal restriction was unconstitutional. The Supreme Court is set to rule in Rahimi. With the hold on the Antonyuk case, this signals that the Supreme Court believes the Rahimi decision will impact Antonyuk.
It's a horrible decision. It's nonsensical. The cyclic rate of fire is similar to that of a submachine gun. A bump stock clearly turns a semi-automatic rifle into a submachine gun. The trigger is pulled once, and the explosive action of the cartridges keeps firing the weapon. The Supreme Court just, lost their common sense.
After Rahimi, we will likely see a grant, vacate, and remand of the Antonyuk case back to the Second Circuit for them to reconsider and reanalyze this issue in light of what is said in Rahimi. In summary, Antonyuk has been placed on hold and has not been relisted for a new conference. This likely signals that it will be held until the Supreme Court issues their Rahimi decision. Once the Rahimi decision is issued, which we hope will be authored by Alito and favorable, it can be used in cases like Antonyuk and others. These cases will be sent back down to the lower courts for a reconsideration of what the Second Circuit and other circuits have said, ensuring a correct application of the Second Amendment as interpreted by the Supreme Court. That's all for this video, folks. We'll see you next time.